How you doing?
Good, yeah.
You ever had a little pocket knife with you?
No.
How about that?
Well,
Yeah.
this is essential for courtroom work. Very good.
Yeah. How you doing? Good. I think you know what happened, Ted, is, yeah, you could probably help me. I tell you what, I just got my nails.
That's the trick.
Yeah, there you go. Okay, great. I think the reason we're starting at 11 is when they started the 6th District Court of Appeal, which is sitting down in Lakeland. Want to come?
Certainly.
They moved a lot of counties around, and Duval, well, the Fourth Circuit, which is of course Duval, Clay, and Furman, not Furman,
Is it?
that's all. I think, I don't really remember any protocols, I just took the left side. Yeah. Yeah.
No jury box.
No, right, exactly. No jury box to get next to. Anyway, they moved all of that from Tallahassee. Appeals from Clay, you used to have to go to Tallahassee. So now you come here.
Where is Duval? I was wondering about that.
What?
Where's Duval?
Here.
Oh, okay.
All three of them, all four circuit.
Barry, do you know, are we going first or is there's another argument today? I don't know if we're gonna go first or the other.
I can't remember.
They both said 11 a.m. on it, so I don't know.
I saw the count. Once you go into one of the bills. I could see. I got those to you are.
Hey, you know?
Which Jackie, are we first?
Yeah, I can see this thing first. Pretty day, that's good.
Anyway. Good.
Say we're first.
Yes.
I have one in the bar.
Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Scott Maycar, Judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning, everyone. Welcome to the 5th District Court of Appeal. We have two cases on our docket this morning. We'll hear argument first in case 24-0369, Clay County Port versus City of Green Cove Springs et al. Counsel, are you prepared? All right, you may approach. And would you like to reserve any time for rebuttal?
Yes, Your Honor, 5 minutes, please. Good morning, Your Honors, and may it please the Court. My name is Tom Schulte, and I'm here on behalf of the appellant, Clay County Port Incorporated, which I'll refer to today as Clayport. Your Honors, this appeal arises from a consistency challenge under Florida Statute Section 163.3215, where Clayport challenged the consistency of a rezoning order that would allow the Hall appellees to build an apartment complex in close proximity to the airport that Clayport owns in Clay County, Florida. But the crucial issue in this appeal relates more to Chapter 333 of the Florida statutes, which is Florida's airport zoning law. And if it pleases the Court, I'll spend most of my time today focused on Chapter 333. The trial court refused to consider evidence of how Chapter 333 affected the rezoning order's consistency with the city's comprehensive plan because the trial court deemed Chapter 333 irrelevant to the consistency analysis.
Counsel, that ruling occurred at the end of the trial, and during the course of this bench trial, is there any evidence that the trial judge prohibited from being entered or blocked from being entered as it would concern the application of Chapter 333 to the facts of this case?
Your Honor, no, there was no evidence that the trial court precluded from being entered into the record. But in the final judgment at page 2799 of the record, the trial court stated that it deemed Chapter 333 irrelevant to the consistency analysis. And then it continued to go on into the consistency analysis without actually undertaking an analysis of how Chapter 333 might play in. And that's
the standard of review in this case. It's an abuse of discretion, correct?
Your Honor, the evidentiary ruling is an abuse of discretion review. But as I believe the appellees pointed out in their brief, the trial court's interpretation of Chapter 333 and how it applies to a consistency challenge under Section 163.3215 is a de novo review because it's the interpretation of a statute, and the consistency statute also requires a de novo review in a consistency challenge such as this one. Your Honors, reversal is appropriate here for two reasons. First, Chapter 333 is relevant under the explicit terms of the city's comprehensive plan. And second, Chapter 333 applies to private airports, including the airport that Clayport owns, which is being impacted by the rezoning order at issue in this appeal. To my first point, Chapter 333 is relevant under the explicit terms of the comprehensive plan. And that's most clearly shown where the comprehensive plan states that a property owner's right to use, develop, and improve their property is, quote, subject to state law, and that's at record site 2461. So by referencing state law, this comprehensive plan explicitly requires the city, and thereby any reviewing court, to consider applicable state law when determining whether a development order is inconsistent with the comprehensive plan. But here, as I said before, the trial court disregarded Chapter 333 entirely in its ultimate analysis of the consistency challenge. It found that, as I said, the trial court found Chapter 333 irrelevant and essentially dispensed with any sort of analysis under 333 as it undertook the consistency analysis under 163.3215.
Did any of the witnesses unequivocally testify that 333 applies to this private airport in this application?
Yes, Your Honor. Our expert witness, Clayport and Pegasus's joint expert witness on aviation, testified that 333 would apply in this scenario because it would apply to private airports. And
Are you referring to witness Halesko, is that correct?
yes, Your Honor.
Okay, didn't witness Halesko, and I'm going to the transcript, page 172 to 173, he stated on cross-examination that 333 only applied to public airports. Is that correct?
Your Honor, if I remember correctly, I believe he had stated that in a prior report that he issued. And that report, which we colloquially referred to, was the Passero report, which was entered into evidence. I believe in that Passero report, Mr. Halesko stated that Chapter 333 applied to public airports. But at trial, Mr. Halesko's testimony related to the fact that Chapter 333 could apply to the private, public, and military airports in the state of Florida, and that the city was required to undertake a consideration of whether there were airport protection or any airport hazards in need of airport protection zoning regulations. Your Honors, considering this consistency plans, the comprehensive plans reference to state law, it's important to consider how Chapter 333 might affect the rezoning order at issue here and whether it's consistent with the comprehensive plan. And several provisions of Chapter 333 bear on this issue. First, Section 333.03, subsection 1A, states that the city must adopt airport protection zoning regulations to regulate airport hazards that exist within the city's territorial limits. And at trial, Clayport offered evidence that the apartment complex contemplated by the rezoning order at issue here could create a hazardous condition and interfere with the safe use of the airport's airspace. And sticking with this theme of safety, Section 333.02 states that airport hazards are a nuisance because they endanger the lives and property of those near the airport. And this theme of safety is important because if the rezoning order poses a safety concern, as provisions of Chapter 333 suggest that it does, that safety concern is certainly relevant to whether the rezoning order is consistent with the comprehensive plan, because the comprehensive plan at its core is intended to further the welfare of the city's residents.
Was safety not considered at all by the lower tribunal?
Your Honor, I don't believe from the lower tribunal the trial court considered safety in terms of Chapter 333.
I mean, just in the overall proceeding, was there any evidence brought in or testimony or documents, whatever, that talked about this is going to be unsafe?
Yes, Your Honor, there was evidence submitted by Clayport and the trial transcript from page 163 to 164. Mr. Halesko testifies that there would be noise and safety concerns with where the apartment complex was situated in terms of where the flight path of the airport was. And in the process of the city adopting the rezoning order before the litigation was initiated, Clayport and our co-plaintiff Pegasus had several times reiterated their concerns that the apartment complex would pose a safety concern.
Well, what I'm getting at to some extent is, okay, the trial judge said I'm not going to consider this statute, but is there sufficient evidence in the record here to support that the issue of airport safety and how this structure might affect it was discussed and formed a basis of the consistency determination?
Your Honor, I don't believe there is sufficient evidence that I don't believe I'm understanding your Honor's question.
Put the Chapter 333 aside, okay? On the record of this case, was there testimony or evidence about airport safety and how the structure of this apartment would affect it, considered by the trial court?
Your Honor, I don't believe... Your Honor, yes, there was testimony by Clayport and Pegasus's expert that this airport would pose a safety concern, and as well as concerns for the noise of the for those that are living in the apartment complex.
Because what I hear your argument to be, hey, the trial judge ignored this statute, it deals with airport safety and the structures around it, and therefore if he had considered it, we would have a different outcome because he would have had to consider safety. And then my initial question was essentially, wasn't it really considered in the record here anyway? And you're saying kind of, but not, I think.
Your Honor, I'm saying that safety was not sufficiently considered in this trial proceeding, and it wasn't sufficiently considered by the city when it adopted the rezoning order, because Section 333.031A requires the city to consider whether there's an airport hazard created by the rezoning order or any sort of development in their territorial limits, and then if the answer to that is yes, to adopt airport protection zoning regulations to regulate that airport hazard. But here, and the trial transcript bears this out, the city did not consider the requirements of Section 333.031A, and rather the only real reference that the city made to Chapter 333 was an acknowledgement that other sections of 333 require a public use airport to adopt an airport master plan. And then after acknowledging that, the city essentially said that because this isn't a public use airport, there's no need for an airport master plan.
Counsel, as a follow-up to Judge Makar's question, correct me if I'm wrong, or is this another case? I don't think so, but there was a buffer between the proposed development, which was a 59-foot structure, and the runway, or the end of the runway, and that was outside the runway protection zone. I believe the trees were in excess of twice the height of the proposed structure. Was there any testimony received, or was there any position taken by your client in front of the trial court that that height and that buffer zone created any sort of safety concern, or hadn't created any safety concern leading up to the point of the trial?
Your Honor, in terms of the buffer being large enough to be outside the runway protection zone, that's correct. The trial record does bear that out. The important point of Section 333.031A is that although the Chapter 333 generally speaks in terms of federal and state metrics for airport zoning, that's not all that the city could consider when undertaking a consideration of airport protection zoning regulations. And here, the city could have, and from our position, should have considered the fact that the apartment complex and the 59-foot tower, even if it didn't violate any sort of federal or state zoning regulation, that it might still nonetheless pose a safety concern. And that's the evidence that Clayport introduced at trial that ultimately the trial court disregarded, was that these apartment complexes could pose a safety concern, notwithstanding the fact that federal and state airport metrics didn't conclusively establish that.
As far as the application of Chapter 333, the trial court also received testimony from Mr. Daniels as far as a conversation that took place between Mr. Daniels on behalf of the city and Department of Transportation, correct?
Yes, Your Honor.
And your client did not challenge that. Obviously, your client, I think the testimony was not a part of that meeting, but yet requested that the city undertake that meeting. But where was the substance of the information received, that being that FDOT didn't believe that 333 applied in this particular scenario? Was that challenged at all in front of the trial court?
The trial court's receipt of that testimony, I believe there was a halfway challenge to it in the fact that we didn't challenge the fact that Mr. Daniels had that conversation and that Clayport had requested Mr. Daniels have that conversation. And we didn't challenge the fact that Mr. Daniels testified as to what his conclusion was at the result of that conversation, but I don't believe there was any entry of Mr. Daniels repeating what was said to him by the Florida Department of Transportation. And on that point, Your Honors, it's important to consider that although the Florida Department of Transportation weighed in on this issue, they are not the governing authority as to the applicability of Chapter 333 to a private airport. And the governing authority on that point is the text of the statute itself. And that leads me to the second point of my arguments, which is that Chapter 333 applies to private airports. It applies by the explicit text, and that's shown in several different references to where the legislature will refer to an airport generally in one section, and then in another section will refer to a specific type of airport.
Counsel, doesn't 333.13 give political subdivisions and FDOT the right to enforce violations of Chapter 333?
Yes, Your Honor, and the DOT is not without any sort of power or relevance, for lack of better words, with Chapter 333. But the DOT can't make the decision that 333 just categorically does not apply to private airports when the statute's text shows that certain sections do. Certainly, some sections do not apply to private airports, but critically, Section 333.031A refers to airports generally. But then if we look to other sections of the chapter, for example, Section 333.01, subsection 15, it's clear that the legislature knows how to differentiate between types of airports that it intends to be covered by a statutory section. Because in subsection 15 of Section 333.01, the legislature defines public use airport. And then again in Section 333.03, subsection 1B, the legislature limits the applicability of that subsection to airports owned or controlled by a political subdivision. And so if the court looks to subsection 1A, the legislature refers to airports broadly. But then in subsection 1B, there's a reference to airports owned or controlled by a political subdivision. And so it's clear that the legislature intended subsection 1A to apply to airports broadly, and the airport protection zoning regulations of that section were to be applied to airports broadly. Your Honors, to conclude here, Chapter 333 is relevant under the explicit terms of the city's comprehensive plan, where the comprehensive plan references state law that the city must consider when engaging in local decision-making. The trial court thus erred by refusing to consider Chapter 333, and this error was harmful because if the trial court had considered Chapter 333, it likely would have found that the residential towers in the flight path of the airport were inconsistent with Section 333.03's directive to adopt airport protection zoning regulations, which the city did not adopt in this case, and which the city did not even consider to adopt. In other words, the rezoning order would pose a problem of being inconsistent with state law, which would not be appropriate under any reasonable interpretation of the comprehensive plan. And so Clayport asks that this court vacate the final judgment and remand with instructions for the trial court to conduct additional proceedings as necessary to consider the effect of Chapter 333. Thank you.
Thank you, counsel.
May it please the court, my name is Wayne Flowers, and along with my co-counsel Brenda Durden, who's in the audience here, we represent the city of Green Cove Springs. The city and the Hall family parties have agreed to equally divide the appellee's 20-minute time for argument. I'll take 10 minutes for the city, and Christy Russell, who is at the table with me, will take 10 minutes for the Hall family parties. The appellees are asking the court to affirm the final judgment entered below, and my argument will focus on the city's comprehensive plan, particularly the relevant provisions in issue here, and how those provisions should inform the court regarding this consistency analysis. Importantly, most of Judge Lester's determinations and findings regarding consistency have not been appealed here and are not an issue here. And in fact, as we've already discussed, the only issues that are left for review here are Judge Lester's determinations that Chapter 333 Florida statutes is not relevant to the consistency determination in this case, and that even if relevant, no evidence was presented showing that under existing conditions that the PUD as conditioned would violate relevant federal hazard or noise regulatory standards which are incorporated in Chapter 333, facts even Clayport's expert did not contest or disagree with. Ms. Russell will focus on the appropriate scope of a consistency challenge and the evidence that was appropriate for use by the city and the lower court in determining consistency of the PUD with the city's comp plan, including Chapter 333. Green Cove Springs, for those of you who don't know, is a small but growing city in Clay County on the banks of the St. Johns River. And like many small Florida cities, it seeks to develop its economy, which includes providing for needed housing stock, particularly multifamily housing, in a manner that is both orderly and reasonable through its comprehensive plan. There's a few important points that the appellees think is very important to make here at the outset of this argument that are critical and we believe undisputed. The first is that Clay County Port, Inc., I'll refer to them as Clayport, is a private Virginia corporation. It is a private entity landowner. They're not an entity of government, and they're no way associated with any entity of government. Second, this is the third of three legal challenges initiated regarding the rezoning of the Hall property. The first was a petition for administrative hearing before the State Division of Administrative Hearings, or DOA, that was brought by Clayport's tenant, Pegasus Technologies, Inc., I'll refer to them as Pegasus, brought pursuant to Section 163.3187, which provides the cause of action for contesting the consistency of a small-scale comprehensive plan amendment with the Growth Management Act, which is Chapter 163. The petition filed in that case by Pegasus alleged non-consistency based on state law compliance issues, including most of the same Chapter 333 issues that have been raised now by Clayport. Clayport didn't join in that action, and it was voluntarily dismissed by Pegasus the very day before the administrative hearing was to commence, after extensive discovery. But because the petition was dismissed, the future land use map designation of the Hall property as mixed use became final and can no longer be contested. The second action initiated by Pegasus that wasn't joined by Clayport was a petition for writ of certiorari, contending based on the record before the City Council that the approval of the PUD rezoning departed from the essential requirements of law. Among other contentions, the claimed departure was the city's failure to comply with Chapter 333. A final order was entered by Judge Lester upholding the rezoning and making specific findings regarding the applicability of Chapter 333 to the rezoning, which have not been appealed and therefore are final as well.
Counsel, do you believe, are you interpreting the sentence in Judge Lester's order, however, even if applicable to a Section 163.3215 challenge, no evidence was offered at trial that the PUD rezoning violates any such standards, record 1503 to 1504, is that evidence that Judge Lester considered the requirements of 333 and found that there was no violation, or even if it was applied, there would be no violation based upon the record evidence and testimony that was received at the bench trial?
Yes, Judge Wallace, I believe he explicitly did that. As you've noted already, there was extensive testimony concerning the two metrics that are in Chapter 333 that are incorporated from Part 77 of the federal regulations that deal with both noise and obstructions. And the testimony was offered, and Judge Lester explicitly found that those standards, there was no evidence to show that those standards were violated.
Well, but Judge Lester also, I guess, made note that there was an offer or there was an order that part of the lease agreements between the individuals that would lease units of the development would then be advised of the potential of a noise problem or noise nuisance. Isn't that correct? That
is correct, Judge Wallace. And again, as we discussed earlier, the executive director and the airport expert for Clayport asked for two things prior to the City Council's approval. One was that they contact DOT, discuss with them any requirements DOT may require related to the airport being there, and that they put a condition regarding a notice to potential lessees of those apartments that there's an airport there and there could be a noise issue. And they did both of those things. So you are correct. That was addressed in the order and was addressed, it was noted in the order and was addressed in the City Council's conditions related to the PUD. The other, again, getting on to the other 2 points that I wanted to make, there were no Chapter 333 issues actually pled in the complaint in the case. And the final point is that the evidence from both parties' experts, as we've noted, their expert agreed that the runway is configured and the development is conditioned meets both of the metrics that exist in law in Chapter 333 for public use airports for height obstructions and noise. And if we need to, we can talk about those metrics, but I don't think there was any dispute. And arguably the only issue that Clayport raises, and they kind of raise it obliquely, is, well, if we wanted to extend this runway to 7,500 feet at some future time, there might be a problem. But of course, there's no present plans for that to happen. They've looked at it several times over the last 40 years and each time decided not to do that. So if I could talk about what we feel are the relevant portions of the comp plan, the mixed-use future land use designation for the Hall property isn't in dispute, as we've said. It specifically says that new development activities will be directed in the appropriate areas of the city as depicted in the future land use map. By virtue of the comp plan amendment, which is, was not contested, contesting was dropped at the last minute, the mixed-use land development designates and authorizes multifamily uses on the Hall property. So in terms of the compatibility issue, in general terms, it is consistent, certainly with the language in the comprehensive plan, because mixed use is designated on the comp plan as appropriate for this property. And so in terms of, there are arguments made in compatibility and specific findings and extensive testimony in the record about compatibility of mixed use and multifamily on this particular, the Hall property, in the final judgment. So the other thing I want to mention is in terms of the comp plan, is the mixed-use rentals park, or the MERP designation for the property owned by Clayport, which was initiated, that designation, that whole MERP designation on the future land use map was initiated by Clayport in 2009. And there are a variety of uses described in Objective 1.7 of the comp plan, and the policies 1.7.1 through 1.7.8 permits a wide variety of uses that includes residential. In fact, it indicates there should be a minimum residential use of 20%, maximum residential use of 65%, with densities even greater than what is allowed through the PUD on the Hall property. There's a character area indicated in there for aviation industries, which are to be combined with multifamily residential opportunities. They argue, in their brief at least, that this recognition of aviation industries, again, somehow bootstraps Chapter 333 into the consistency analysis. I would suggest that it doesn't. My 10 minutes, I believe, is up, so I'm now going to yield to Ms. Russell.
May it please the court. Christy Russell on behalf of the Halls, who are the property applicants and owners and who intervened as defendants in this action below. And also here with me today is my partner, T.R. Hainline, who was trial counsel in this case. The court should affirm the trial court's decision for two reasons. The first is the trial court correctly determined that Chapter 333 was not relevant in this comprehensive plan consistency challenge. Second, the trial court correctly determined that even if Chapter 333 were relevant, there was no evidence put forth by the plaintiffs in the case that there was any violation of any federal or state administrative standard. This case is...
Counsel, why doesn't the simple reading of policy 10.1.1b, the rights of a property owner to use, maintain, develop, and improve his or her property for personal use or for the use of any other person shall be subject to state law and local ordinances. Why doesn't a plain reading of that language in its reference to state law incorporate a consideration of Chapter 333?
Well, in order to read it that way, Your Honor, it would have to be read to incorporate any state law into the comprehensive plan. And the language that Your Honor is reading from is proposed form language set forth in Chapter 163, 3177 for use in a local government's private property element. I think the plain reading of that is that it talks about the scope of the private property owner's rights. In other words, the local government has to take those rights into account but of course they're subject to state law. I don't think that provision can reasonably be read as implementing state law generally. In order to do that, the local government would be turned into an enforcement mechanism, essentially assuring that state law is complied with. In this particular instance, Chapter 333's enforcement is left to the Florida Department of Transportation, not to local governments. And so to read it the way Clayport is suggesting would be to essentially incorporate every state law into the comprehensive plan.
So your position is that that phrase should be used as a right to your clients, but not as a limitation to what your clients want to do on the property, as opposed to it's a limitation to the appellant's rights in this particular course of action.
I think it acts as a limitation if a property owner wants to do something that would be contrary to state law, Your Honor. But in this case, the comprehensive plan doesn't make any reference to Chapter 333 or airports or runways at all. The comprehensive plan doesn't speak to that. And so to read it the way the plaintiffs would want it read would mean that one thing that we've struggled with is what exactly was the trial court to determine was inconsistent with the comprehensive plan. The Hall's property was designated through a comprehensive plan amendment as mixed use. And most of the trial, the majority of the trial, was addressed to whether or not the rezoning was compatible and appropriate in a mixed-use land use category. So the question becomes, what was the trial court to determine was actually inconsistent? Was it to incorporate and look to Chapter 333? Was it to have determined that the city was to stop its consideration of the zoning regulation, the rezoning application, adopt regulations under Chapter 333, incorporate those into the comprehensive plan, and then determine that there was some inconsistency? The focus of a Chapter 163, 3215 proceeding is on the consistency of the development order with the comprehensive plan. To read that provision would basically put a burden on the trial court to determine consistency not just with the comprehensive plan, but with any state law that a challenger would say needs to be incorporated. And I think it's very relevant here that the appropriate place to challenge the mixed-use land use category change that was done through the comprehensive plan amendment would have been an administrative proceeding with the Department of Administrative Hearings. And any affected individual can file that. In fact, Clayport's tenant did file that action. In that type of action, the administrative law judge is empowered to look at whether or not the local government's proposed comprehensive plan amendment here, changing the category to a mixed use, complies with state law, including Chapter 333. That proceeding was dismissed by Clayport's tenant Pegasus the day before the hearing, and this evidence was all teed up for the administrative law judge to hear. And Clayport itself never filed that type of administrative proceeding. That would be the proper forum for that kind of consideration. The other type of forum that would be appropriate might be some kind of action asking FDOT to enforce Chapter 333 if there was some question that the city had not done what it was supposed to. And again, that's not this type of proceeding. The other type of thing that might have been possible was to raise that as part of a petition for writ of certiorari. The trial court denied Clayport's petition for writ of certiorari, and the standard there is there a departure from the essential requirements of the law. Clayport did not seek further review of the trial court's denial of the petition for writ of certiorari. So I think there are appropriate places where that issue can be raised. I mean, our position would have been in the administrative challenge. Chapter 333 is not relevant to private airports, but the issue was teed up to be heard there, and that makes sense because the Department of Administrative Hearings is going to be charged with applying that state law and making sure that comprehensive plan amendments are in compliance. Here, the comprehensive plan is what the trial court is looking at. Is the development order consistent with the comprehensive plan? The reading that's being proposed by Clayport would be, well, you incorporate essentially any state law, and you charge the trial court with looking at whether or not this proposed development order complies with state law. That is clearly outside the scope of what the legislature intended. It's a very limited statutorily created remedy, and the trial court is to look at the development order and the comprehensive plan. The court inquired as to whether or not there was testimony by Mr. Halesko as to whether or not Chapter 333 applies to private airports. I think Mr. Halesko did agree that it does not, with our position that it does not apply to private airports. Starting at page 173 of the trial transcript of the record, Mr. Flowers was cross-examining Mr. Halesko, and he says at line 14, yes, sir, you concluded there, and he's talking about a report that was prepared for this property, you concluded there that Reynolds Park was not included in Clay County's zoning regulations because the airport is privately owned, private use airport. Is that right? Answer, yes. He goes on in his cross-examination on page 174 of the trial transcript record. So the tie between having to establish the ordinance, at least based on what you say there, is with becoming a public use entity. Answer, yes. Page 175, Mr. Flowers was talking about a PowerPoint that was distributed. That is an exhibit. It's actually Defense Exhibit 1 in the record on appeal. He's talking about 2 bullet points. And the question is, so again, 2 bullet points that were in the PowerPoint. One of them was Clayport private equals no height zoning regulations. Bullet 4, Claypoint public equals height zoning regulations will need to be established in Green Cove. And the question then, so again, you are equating the need for or the adoption of airport zoning regulations with the airport becoming a public use airport. Answer, yes, and that's on page 175 of the record. The other portion of the record that I think is critical is Mr. Halesko's testimony at pages 181 and 182 of the record, where Mr. Flowers cross-examined him on the applicable federal and state standards and whether he felt that there was any violation of either a noise metric or an obstruction metric. Would the 59-foot buildings constitute an obstruction under federal law as incorporated through Chapter 333? And Mr. Flowers' question on page 182. And I think you agree that in the current configuration, both of those metrics are met, both the height metric and the obstruction metric and the noise metric. Answer, yes. So I think that, again, the trial court was entirely correct that Chapter 333 was not relevant in this consistency proceeding.
I can ask a quick question. 333.031A, which deals with every political subdivision shall adopt zoning regulations. The city hasn't adopted any regulations, correct? Okay, so they take the position that this doesn't apply to them.
Correct.
So assuming it did apply to them, how would someone go about forcing them to have regulations consistent with that provision?
I think perhaps you'd have to ask FDOT to enforce those. I think the opportunity to make that argument has passed because nothing was filed at the comprehensive plan stage when it could have been filed with DOA.
Because if I'm the trial judge in this case, I say, okay, well, yeah, it says they're supposed to have regulations. They don't have regulations. What am I to do with that? I'm just here on the consistency thing. That's your point, which is this is a different animal than...
Yes, Your Honor.
Right, so...
I think a petition for writ of mandamus, perhaps asking FDOT to take action if required.
If you want to take a moment just to conclude.
Yeah, thank you, Your Honor. So the trial court's decision was correct, both as a matter of law because Chapter 333 does not apply, and because the trial court correctly determined that even if it did, there were no violations of any applicable standards. For those reasons, we respectfully request that the court affirm the final judgment below.
Okay, thank you. If the marshal would add 24 seconds to appellant's time. Thank you.
May it please the court. Your Honor, to address what Ms. Russell was addressing right before she sat down of sort of what is the trial court to do, that illustrates why a remand here is appropriate, because on remand, this court could instruct the trial court, as we asked for, to conduct such additional proceedings as necessary. And so what does that look like? For us, Your Honor, for Clayport, an appropriate option would be for the trial court to instruct the city to actually undertake that analysis under Chapter 333 and determine whether airport protection zoning regulations are needed. Not because this is a bootstrapped 333 action, but because, as Judge Wallace pointed out, the comprehensive plan requires the use, development, and improvement of a property owner's property to be subject to state law, which inherently requires a consideration of that applicable state law. And on that point, it's not, as the appellees sort of stress, it's not every state law on the books, right? The city doesn't have to sit down and read every statute.
I'm sorry to interrupt, but I'll keep your thought, but I'm struggling because 031A talks about the entity, political subdivision, shall adopt regulations. Okay. I mean, that's a whole different issue here. I think you're saying is that this proceeding below should have considered, if there were regulations, whether this project, this PUD, whatever, complied with those regulations. But there aren't any regulations. So I'm not sure, it's kind of circular.
Your Honor, respectfully, that's not our position. Our position is that the city should have undertaken the analysis in the first place. And perhaps they reach a conclusion that says we considered Chapter 333, specifically the airport protection zoning requirements under subsection.
But is there a uniform set of airport regulations out there that the city should adopt?
No, Your Honor, there's no uniform set of zoning regulations. And that's why it's critical here for the city to at least undertake the analysis because, and we introduced this in the post-trial motion.
But they can't because they don't have regulations. They can't apply the regulations here because they don't have any.
The consideration would be to whether to adopt any airport protection zoning regulations in light of the fact that there's going to be a 59-foot apartment complex in the flight path of the airport. And Your Honors, to a point that both Mr. Flowers and Ms. Russell made, is they emphasize that no federal violation has happened here. But I want to reiterate, that's not the only thing that the city could or should consider when undertaking whether to adopt airport zoning regulations.
Could or should really isn't relevant, is it? It's
Sorry?
What are they compelled to adopt? It's not what they could adopt, what they should adopt. It's what are they compelled to adopt?
Correct, Your Honor, and that's not what Clayport's action is challenging, is that they should have adopted any specific airport protection zoning.
Just more.
It's just some, Your Honor, is that they should have at least considered it, and from our perspective, they should have adopted some.
Seems pretty abstract when you have the burden of showing that they weren't in compliance.
Your Honor, our burden here goes to the comprehensive plan and showing that there is an inconsistency in the comprehensive plan. And to, I guess, make a quick point of clarification here, the court's review in a consistency challenge of a comprehensive plan is de novo, and it applies a strict scrutiny review, which actually places the burden on the city, the local government, to show consistency of the rezoning order. And that's where the burden is important here, because this is not an action under Chapter 333, despite the appellees trying to paint it that way. This is an action where Clayport is challenging the rezoning order that allows an apartment complex to be built in the flight path of an airport that's being active in the state of Florida. And as Judge Wallace pointed out, the comprehensive plan specifically requires the city, when engaging in local decision-making, such as rezoning, to consider applicable state law, is that the development order and the development rights issued by the rezoning order must be subject to state law. But here the the city, and thereby the trial court, didn't consider any of the applicable state law. And that's why we're arguing for a reversal here and a remand to instruct the trial court to conduct additional proceedings as necessary to allow the city to consider what might be required under Chapter 333. Thank you, Your Honor.
Thank you, counsel. All right, next on our docket is case number 24-148, Steak and Shake, Inc. versus Amber Nicole Spears and Eric Spears. Counsel, you prepared to?
Yes, sir.
All right, please proceed.
May it please the court, I'm Lindsay Lawton. I'm here on behalf of Steak and Shake, the appellant, and I would like to reserve 5 minutes for rebuttal.
Thank you.
Thank you. Your Honors, Steak and Shake is here today to ask that this court enforce the exclusivity bar of Section 440.11 through this appeal. Section 440.11 provides that an employer's liability for an injury to an employee under the workers' compensation law shall be exclusive and in place of all other liability. There are only 2 exceptions to this exclusivity bar. One is if the employer doesn't obtain workers' compensation insurance, and the other is for an intentional tort. Neither of those exceptions is at issue here. Section 440.11 provides no exception to this exclusivity bar for a purely psychological injury, which is what is at issue here. And so that means Steak and Shake is not liable in tort for the injury at issue here, and the trial court should have granted the motion for summary judgment. To overcome the effect of the statute, the appellee has relied on the conclusion that her injury is not compensable in the workers' compensation forum. That is not an exception to the exclusivity bar, and not a valid argument for 2 reasons. The first is she has not tested this assertion that her claim is not compensable in the workers' compensation forum by presenting a claim in that forum. The circuit court is not empowered to decide the compensability of a workplace injury through workers' compensation.
Well, does every claimant have to do that?
I'm sorry?
Does every claimant have to do that? Is it, I don't recall from my first BCA years whether they absolutely have to go into the workers' comp system to see if they have coverage there before they can bring a private lawsuit.
Well, our argument is that is basically the effect of the existence of the workers' compensation law and the exclusivity bar. Case law is replete with statements explaining that the workers' compensation law is the employee's exclusive remedy for the employer's
Right, but if I'm the employee and I'm injured and I take the position that it was an intentional act, do I still have to go through the workers' comp system and get a ruling at some point that it is an intentional act? You need to be over in the state court litigating it, or can I just go to state court and file the action for intentional?
I think under that situation you could go to circuit court because that is an express exception to the exclusivity bar. But since the exclusivity bar doesn't provide any exception for any other type of injury, then they have to go to the workers' compensation forum first.
So I think I am somewhat sympathetic to your argument about the text of the statute saying that it is exclusive and in place of all, let's bold that word, all other liability. I might also be sympathetic to the argument that courts should not be rewriting statutes. But I'm looking at the language in Aguilera, where the Supreme Court specifically seems to conflate in a binding way, compensability with applicability of the statute, the exclusivity portion, where it says, immunity extends only to, quote, an accidental injury or death arising out of work performed in the course and the scope of employment. So in other words, not everything, just those accidental injuries that happen in the scope of employment. If I then compare that to the language of 93, that a mental or nervous injury due to stress, fright, or excitement is not an injury by accident arising out of the employment, it seems we have not a precedential, but a statutory exclusion here. Can you walk me through why that analysis might be wrong?
Yes, thank you for that opportunity. So section 440.093 is not about immunity. You have to read that section in the context of the entire chapter, and indeed in the context of other language within that section itself.
Well, specifically reading it in context of that language from Aguilera, which seems to now like I said, conflate in a binding way compensability with your immunity.
The case you're citing is, you say, Aguilera? I don't believe we discussed that in the briefs, and so I'm not completely familiar with I'm not familiar with the facts of that case. The language that the court is using, though, that you're quoting, is reflective of section 440.011, or .11. And I don't believe that the Aguilera case was addressing the specific issue we have here today.
To be clear, that case and the line of cases following it seem to be dealing with intentional torts primarily. But the reasoning and the express language used by the Supreme Court, it says liability is limited to, or I'm sorry, not liability, immunity extends only to. That gives me a lot of pause.
I understand that, but I would say we have the Aguilera language, but also we have language from the Florida Supreme Court in Ella versus Shova that says, under the Act, workers' compensation is the exclusive remedy available to an injured employee as to any negligence on the part of the employee's employer. And so while Aguilera may be using some other language when they're talking about intentional torts, we have language in Ella versus Shova saying when we're dealing with negligence, you have to go through the workers' compensation scheme. And we also have that same language in the First District case, McNair. It says, excluding exceptions not relevant here, Florida's statutory workers' compensation scheme provides the exclusive remedy for an injured employee. Likewise, in this court's decision in Kent, it says the Florida legislature has created a comprehensive process for consideration of claims against employers relating to the on-the-job injuries sustained by their employees. So in this case, there's no dispute that the injury happened on the job. It arose in the course and scope of employment, just as a matter of objective fact. And I understand that.
As a matter of objective fact, yes, but as a matter of law, no. 093 specifically says that is not that thing.
And again, Your Honor, my response to that is that you have to look at 093 in the context of the whole chapter, and you have to consider the very next sentence after the one you're quoting, which says that benefits are not payable for this type of injury. And so the purpose of the statement saying that this is not an accident arising out of employment is not to say that this type of a claim doesn't belong in the workers' compensation forum, but to say that when it gets there, there aren't benefits available. And that is because the legislature decided to apply in the workers' comp forum basically the traditional tort impact rule, which doesn't allow recovery for purely psychological injuries if you don't have an accompanying physical injury. Of course, in the current tort world, you can get that type of recovery from just a touching, basically. But under the workers' comp statute, you can't. And that was, as you know, the laws that existed in 1968 when the Florida Constitution, the current version, was enacted, and that is the law now. And if we allow the appellee to overcome sections 440.11 because she did not sustain a physical injury, that circumvents the workers' compensation scheme, and it leads to an absurd result. It means that someone who sustained a greater injury by, for example, having a heart attack during the robbery and also having psychological trauma would be limited to the benefits available through workers' compensation. But someone who only had the psychological injury could go to circuit court and get unlimited, potentially, recovery for the psychological injury. And
Well, I guess the heart attack would be a physical injury?
it would.
Okay. So if the robber comes in and says, everyone get back into the freezer in the back of the restaurant here, and holds a gun to their head, and that's not compensable because there's no injury, right?
That seems to be the case, but again,
Under the statute, under the workers' compensation system, sorry, even if the employer was entirely negligent and failing to have any training about these situations, failed to have any security in place, and whatever, the legislature said tough luck. So they've kind of taken away that cause of action.
that's right, but it's important to remember that cause of action didn't exist under traditional tort law either. There was traditionally a requirement that you have a physical injury, and the legislature has said that, even though in regular tort litigation, the courts are now allowing recovery for that type of injury without a physical injury. Workers' compensation isn't going to do that. And that is because the legislature decided that in exchange for the automatic payment of benefits for physical injuries, or even psychological injuries that are accompanied by physical injuries, the employees are giving up some rights.
Well, isn't there an independent cause of action here that the plaintiff has? I mean, isn't there an independent tort action the plaintiff has that has been given up under the workers' comp system? Haven't they given up access to courts, I mean, under the constitutional provision that seek redress for that particular claim? That's how I'm conceptualizing why they're here today, which is that they brought an independent tort claim for this type of injury that's not compensable under the workers' comp, but would be compensable under the tort system.
That's correct. It would be compensable potentially under the current tort system, or at least, we wouldn't be asking to dismiss it. Well, there were some arguments below about whether the current impact rule is met, but assuming that the current impact rule in tort litigation wouldn't be a bar to her suit.
I don't remember the Supreme Court case where the challenge under access to courts under the Florida Constitution. What they can take away. What can the legislature take away and force everyone into the workers' comp system and to ensure that it's still constitutional? I don't recall whether, can you take away a cause of action? You retain 99 causes of action, but one is taken away. Is access to courts been denied or not? I don't recall. Do you? Okay.
I do. There's a couple of answers to that. So the legislature can take away a cause of action as long as there is a reasonable alternative through the workers' compensation system.
And here there's not. In this particular case, there's not.
Her argument is that there isn't one, but that theory hasn't been tested through the workers' compensation system.
Okay.
But additionally, it's important to remember that if the cause of action that you're asserting is being taken away did not exist for you in 1968, then there's no access to courts problem. And that's the situation we have here, because in 1968, the tort impact rule was the same as the statutory impact rule for workers' compensation. If you have no physical injury under that traditional rule, you can't get a recovery for a psychological injury. And so, yeah, I understand that it's certainly terrible what happened to Ms. Spears, but her remedy is simply just not from stake and shake through a tort action, because that's what the legislature decided. And again, I would just point you back to multiple cases, including Ella, McNair, Kent, saying that when you're talking about negligence as opposed to intentional torts, the employee's remedy for an injury is through the workers' compensation system. And Kent explains that just because the employer would have a substantive defense within the workers' compensation forum, meaning that the employee can't get benefits, doesn't mean the courthouse doors are open. It means there's a substantive law saying that under the legislature's judgment, benefits aren't payable in this situation. And that's exactly what we have here.
If the intruder here had, with Rob or whatever, if he touched her, if he'd scratched her, requiring a Band-Aid, would that have fallen under the statute? And you'd have to provide compensation?
Are you asking if that would she be entitled to benefits under the workers' compensation system?
Yeah, because physical injury requiring medical treatment. You have to have an accompanied physical injury requiring medical treatment.
So that would be a question that only a JCC or a carrier could answer, because
That's, okay.
And I'm saying that partly because I can argue maybe it wouldn't, because that's not. There would be a question about, is that medical attention? Is that medical treatment a
So some
Band-Aid?
carriers would define that as medical treatment and others wouldn't. A Band-Aid.
Maybe so, and if that happened, then the claimant could take the dispute to the JCC. And the JCC could say, is that an injury requiring medical treatment or not? If the claimant didn't like the answer, the claimant could then appeal it to the First District Court of Appeal. But what the claimant can't do is skip that whole process and ask the circuit court to decide that, because that determination is within the exclusive subject matter jurisdiction of the JCC and then the First DCA on appeal. And so what we're asking today is simply that the court enforce Section 440.11 and abide by all the case law from this court and the Florida Supreme Court, saying that when there's an injury caused by negligence, that injury has to be litigated in the workers' compensation forum. If it is an employee's injury and the employee is trying to get compensation from the employer. And if there are no further questions, I will save the rest of my time for rebuttal.
All right, thank you.
Thank you.
Good morning, Your Honors, or afternoon now, 12 exactly. I'm Jack Hamilton. Sitting with me is Madison Cacciatore. We are with the Melbourne law firm of Nance Cacciatore. We represent the appellee in the case, which are the appellees, Amber Spears and her husband Eric. The Florida Constitution allows redress under Article 1, Section 21. The court shall be open to every person for redress for any injury, and justice shall be administered without sale, deny, or delay. Florida Statute 2.01 basically says that the common law and the statutes of England are part now of the laws of Florida, and they adopt basically the common law of Florida. The Willis case is the Supreme Court case, which is exactly on point in our case. The facts are virtually identical, except that she wasn't an employee, but there was a touching of her during this robbery. A gun was put to her head, and she filed a claim for negligent infliction of emotional.
Well, then it wouldn't be exactly like your case then, because it's not dealing with the workers' compensation statute at all.
It's not dealing with the workman's comp, but it basically confirms the common law remedy of negligent infliction of emotional distress as part of the common law of the state of Florida. So this is a constitutionally protected cause of action that our client has filed, and the defense is simply that they're immune from suit because it's workers' comp. It's not workers' comp. The statute, and we've talked about it already here this morning, but 440.093 couldn't be any more explicit. A mental or nervous injury due to stress, fright, or excitement only is not an injury by accident arising out of employment. And then in the last sentence, a physical injury resulting from mental or nervous injuries unaccompanied by physical trauma requiring medical treatment shall not be compensable under this chapter. This is not a workman's compensation case. It falls outside of the workman's compensation case.
So let me ask you this. 440.11 does say all other liability. We do know that that has been somewhat narrowed by the Supreme Court, but it seems to me that that narrowing has been in the nature of intentional torts. If we were to follow your argument here that the combination of the Supreme Court saying all doesn't mean all with 440.093, would we be expanding the exceptions that have been laid out by the Supreme Court beyond intentional torts?
Well, I think the statute itself says very specifically. I mean, it's not just an exception to workman's comp. A mental or nervous injury without physical injury requiring medical treatment is not even included in workman's comp, specifically according to 093.
Well, you miss an intermediate step there, because like I said, 440.11 only deals with the immunity provision, the exclusivity provision.
Right.
For us to say that exclusivity is the same as compensability requires that extra step of looking at the Supreme Court's opinions that say this only, your immunity only applies here, because the statute itself says immunity applies in all cases of liability.
Well, but I think it has to be interpreted in terms of just common sense. I mean, there's no situation that I'm aware of where you can deny somebody a constitutionally protected cause of action without giving something in return. And in my brief, I cited, the no-fault law.
And that may be very well the case, but in that case, would not the correct challenge be to 440.093 saying, well, this is unconstitutional, rather than saying the entire workers' compensation immunity system is unconstitutional? And since we haven't done that, are we kind of putting the cart before the horse?
I don't understand really what you're saying, Your Honor.
Well, we would be presuming the unconstitutionality of 44093 there, when that hasn't been challenged and that hasn't been determined.
Well, I'm not presuming that it's unconstitutional. I'm presuming that it is constitutional and that it says and the words are what they are.
For us to say that there would be no remedy available, and that would be unconstitutional because there is no remedy available, would be for us to, sorry, I'm kind of circling around myself at this point, would be for us to say that the challenge should be to the immunity provision because it does not provide access to the courts, rather than the challenge would be to 44093, saying here is where that prohibition lies.
Well, I think statutes have to be read, in conjunction with each other. And I think, the Workman's Comp, Chapter 440, which encompasses 44011 as well as 44093, have to be read, there's a Latin term for it, but in conjunction with each other. And when you do, it's very clear that the injury suffered by Amber Spears is not a physical injury requiring medical treatment, and therefore does not fall within Workman's Comp. The idea from the defense is that she has no remedy for a constitutionally protected cause of action. And according to, Article 1, Section 22 of the Florida Constitution, that can't be. And if I may, when we move on, there's language in the McKenzie case, which is cited in my brief, which says specifically that mental or nervous injuries caused by being held at gunpoint are not compensable under Chapter 440. The first, and I'm reading from the opinion, on page 2, the first sentence in Section 440.0931 provides a mental or nervous injury due to stress, fright, or excitement only is not an injury by accident arising out of employment. Examples might include a situation where an employee experiences mental trauma after being robbed at gunpoint, but does not suffer a physical injury requiring medical treatment. Although the legislature recognizes that such mental or nervous injury exists, they are not compensable pursuant to Chapter 440. So, the cases are, the courts are interpreting that the legislature understands that this is something that simply, they recognize this cause of action, but the legislature has decided that it's not compensable and not included in Chapter 440. In the Acton case, which was cited by appellants, a common law cause of action cannot be taken away without providing a reasonable alternative. This is again the Supreme Court of Florida from 1983. And the language there, and they cite Kluger versus White, which is another Supreme Court case in 1973, where a right or access to the courts for redress for a particular injury has been provided by statutory law predating the adoption of the Declaration of Rights of the state of Florida, and this is the sentence that was left out by appellant's counsel, or where such right has become part of the common law of the state. The legislature is without power to abolish such a right without providing a reasonable alternative to protect the rights of the people of the state to redress for injuries, unless the legislature can show an overwhelming public necessity for the abolishment of such right, and no alternative method of meeting such public necessity can be shown. There's no such showing. There's no such attempt by the legislature to show that there's an overwhelming need to abolish this cause of action. So the legislature is without authority to do away with it. So anything
Well, counsel, let me, on that thought, the reasonable alternative issue.
Mm-hmm.
What the legislature does have, I perhaps would argue, or perhaps they would argue, the reasonable alternative here is they have preserved the cause of action. Negligent infliction of emotional distress still exists. The only difference now is that you have to have a physical injury requiring medical treatment. So there is, some might say, oh, that's unreasonable, because sometimes you'll be injured, have a mental injury without a physical injury requiring medical treatment. So why isn't, the 440.0931, why isn't the statutory cause of action, why isn't that a reasonable alternative?
Why is that a reasonable alternative?
Why is the statutory cause of action that requires physical injury requiring medical treatment, why isn't that statutory cause of action a reasonable alternative for the common law claim of negligent infliction of emotional distress?
Because the negligent infliction of emotional distress, there is no physical injury requiring medical treatment. So I mean, they're two separate categories of injury. One is physical injury.
But it doesn't have to be perfect fit. What I read it to say is reasonable alternative means it doesn't have to be the same thing, but but it has to be a reasonable alternative.
But,
And I'm asking, why is this unreasonable?
well, I'm just saying there is no, I mean, she has no alternative. There is.
I'm just giving you a statutory one. I'm asking you, why is that not reasonable?
I'm sorry, because there was no physical injury in her case.
Well, that's why they're different, but why is this one not a reasonable alternative?
Again, I'm having trouble following what you're
Okay,
saying, Your Honor.
go ahead, that's fine.
Our position is that workman's comp immunity only applies to cases that fall within workman's comp. It doesn't fall, if you were to file a claim against your employer for wrongful termination or age discrimination or sexual harassment, you don't have to file a workman's comp case first and have it denied. This is a totally separate cause of action. It's protected by the Constitution of the state of Florida, and all the case law. That Willis case makes it very clear that it's a well-established cause of action under the common law of Florida. So our position is that Judge Jacobus's order denying their motion for summary judgment was correct, and it should be affirmed by this court. Thank you.
The Willis case is from 2007, and so while it might be that Ms. Spears would have a cause of action under the Willis case, the important question for the access to courts inquiry is what was the state of the law in 1968?
Is that the year the workers' comp system was adopted?
That was the year that the current version of the Florida Constitution was adopted, or I guess the main. Obviously, it gets amended from time to time, but that's what the case law says is the important year. I think the workers' compensation law existed before that, but so I mean you could look before that or you could look in 1968. But either way, the tort law did not provide a remedy for a person who sustained a psychological injury without.
So what's the best case that you can cite for the negligent infliction of emotional distress not existing at that time? In 1968?
I guess actually the Willis case, in Justice Quintero's dissent, he goes through a litany of cases showing that from 1985 up until the time of the Willis decision, the courts were requiring there to be a physical injury.
But you said 1985.
Did I say? I'm sorry. Let me just look at my brief here. I quoted it in a parenthetical. Just this. So I didn't identify like what's one specific case, but I pointed out that there's a litany of cases that were discussed by Justice Quintero in his dissent, showing over the course of many decades that there was no tort recovery for a psychological injury without an accompanying physical injury. In fact, I can point out this court's case in Davis from 1981, where the court said if you don't, at that point in time, if you did not have a cause of action in tort, you also didn't have one in workers' comp and vice versa. All because of the impact rule. And I would say, just back to Judge McIver's point about 440.093, that language, I just want to reiterate that it's important to look at the language of the statute and body of case law as a whole, which shows that workplace injuries are to be adjudicated in the workers' compensation forum when the issue is negligence. And I understand the Aguilera case talks about intentional torts, but I also want to point you back to 440.11 because 440.11 itself establishes that an intentional tort is an exception to workers' compensation immunity. So to the extent the Florida Supreme Court was just saying that there's an exception to that all liability language because of an intentional tort, that comes from the statute itself. But what 440.11 doesn't do is provide an exception for this situation when there's just a psychological injury unaccompanied by a physical injury as a result of the employer's alleged negligence. If there are no further questions, then I would just ask the court.
Well, I was expecting you to follow up on my question about reasonable alternative. Do you have any response to that line of thought? Like whether the statutory provision in this case?
Yes. Okay, thank you. So I mean, I'm going to answer your question, but I wanted to reiterate that you
I
don't
thought
have
your
to have.
answer- I thought your answer would just be, that, yeah, the statute provides a reasonable alternative, let's go home. No?
Well, of course it does, because remember, the workers' compensation law does not preclude recovery for psychological injuries. It requires a very minimal requirement that there also be a physical injury requiring medical treatment. That can be a very minor injury, as long as it occurs in the same incident and, you know, the psychological injuries are related to that physical injury. And so the case law says that, you know, tweaking the elements of the cause of action isn't diminishing it altogether. It's still providing a reasonable alternative. And that language is quoted in the brief from a Florida Supreme Court case, that just tweaking the elements of damages is not a denial of access to courts. And at most, that's what we have here, because the workers' compensation law does allow recovery for psychological injuries. It just sets the bar a little bit higher for what the employee has to prove in order to get those benefits. And I would just ask that you enforce 440.11 and not open the door to the courts for people who are less injured than what the workers' compensation law says is required to get an employer to pay compensation for negligence that causes an injury. Thank you.
All right, I thank both counsels. We will be in recess.